Absent, however, from the system of adjudication is arbitration. To address the severe backlog of cases which have become trapped in the system requires the utilization of a complementary system of dispute resolution. Arbitration presents itself here as one of the effective tools critically considered. The present system, unless radically overhauled, simply cannot meet the fair and reasonable expectations of the local citizenry. The resolution of a civil dispute requires minimally a fair opportunity for litigants to put their case within a reasonable time, at a tolerable cost level, and with appropriate independent input to ensure fairness. Arbitration possesses all these elements once properly harnessed. ADR has had, outside of Barbados, a long and respected history. Many jurisdictions, especially those which have modeled their civil procedure rules on the English model, have given increased importance to ADR. We have here, fortunately, a reforming government, a bar with several lawyers trained in arbitration, and a Chief Justice designate who needs no conversion, with a positive contribution that can be extracted from ADR. All the essential elements are in place. All that is missing is a need for energetic leadership to ignite the process, which I intend to offer. I thank you very much, Dr. Malcolm.
Thank you very much, Mr. Cheltenham, for your very kind words of welcome and for telling us about some of the wonderful things that you'll be doing when you assume office. At this point, we will ask Mr. Maurice Stoppy, in whose honor the lecture to be delivered is in fact after whom it is named. And we'll ask Mr. Stoppy to also give his words of welcome, of greetings, before we turn over the moderated aspect of the proceedings to Ms. Karen Goff. Mr. Stoppy?
Muted. You're muted. Not hearing. Not hearing.
Unmute yourself, Mr. Stoppy.
Is that better?
Yeah, yes, you're okay.
Okay, I'll do my best to begin again. I was just beginning by telling Mr. Secretary General, and I was addressing my remarks to our distinguished guest speaker, the Honourable Minister, who we heard from earlier, who seems to have more hats to wear as the size of his head will allow, but I'm sure that he's going to manage with our help, of course. Distinguished guests, ladies and gentlemen, fellow arbitrators. As a proud member of the Jamaica International Arbitration Center, I'm especially happy and grateful to add my words of welcome to all who are participating in this electronic webinar, if that is the right expression to use, and look forward to an exciting and rewarding evening. Welcome. We have the dreaded and inescapable COVID-19 pandemic to thank, if that is the right word, to bring us together in this new and highly efficient way. There may be some who are completely at home and accustomed to using the system. For others like me, not quite so, but we're trying to feel our way. Either way, I congratulate our Secretary General for organizing this series of webinars and look forward to this evening to the birth of new thinking and paradigms in the field of arbitration and arbitral practice that will emerge therefrom. In any case, being a proverbial optimist, while acknowledging many social and intellectual drawbacks to the disease, I prefer to look at the silver lining, which we hope is within each cloud. The disease affects all on this planet equally and may be viewed as a challenge rather than a curse. And perhaps even seen as benefits such as the great savings that it incurs in administrative costs and procedures such as the one we are active in this evening, and traveling time and so on, and and it demonstrates the greater need for the participants to be more familiar with the process and the system. Personally, I see it as a challenge to our traditional and perhaps evolutive experience in dealing with personal and professional relationships, in which we have habitually learned by us, by training and over time, to enable us to function as efficiently and affordably as we would wish. Now restricted, of course, within the social and medical constraints of the disease. I'm also mindful, fellow Arbiter, tremendous advantages to members of being able to exchange both locally and now internationally ideas, printed material, technological information, and even the instant exchange of abstract ideas between individuals and groups, whilst remaining in their native habitats. And as we are hopefully going to enjoy them here this evening, in conclusion, I would like to add my personal congratulations to the newly elected Chief Justice of Barbados. And on a very personal note, I don't know if he remembers, but we were together in a case more years ago than I care to remember in St. Lucia. And so if I could have joined him either this evening or at some future date with a glass of Mongay in my hand, I would happily and gratefully do so. Thank you, ladies and gentlemen.
Thank you, Maurice, and for your very kind words and offer of a drink with our minted chef. But at this time, I wish to acknowledge some of our kind sponsors, including the Caribbean Development Bank, ADEB Consultants, Jamaica Standards Products, Island Blue Jamaica Mountain Coffee, Guardian Group, Jamaica National Bank CPM Consultants Limited, Jamaica Deposit Insurance Corporation, Virgin Gorda Villas Luxury Property, Burroughs and Wallace Caribbean Producers Jamaica Limited, Money Must Rum, and Culture Walk. And at this point, we're going to ask one of our sponsors from ADB Consultants, a sponsor rep, Martel Lee, to give us his quick words. Thank you, Martel. The floor is now over to you, Martel.
Well, Chris, thank you very much. You know, I wasn't prepared for this because I've been working all day and all night last night. But let me first and foremost congratulated all members of this panel for making yourselves available. And first and foremost, I want to say that we had, for two reasons, wanted to sponsor the this webinar. One is that I've known Maurice Stoppy for a very long time. After joining the construction profession, I think we have met on a number of key projects. Not sure if he remembers because it started about 30 years ago. As a young professional, I admired his high level of professionalism and his willingness to share his knowledge at all times, regardless of the time expense to him and circumstance. We have, over the years, worked on a number of key projects. One of them, and the landmark one, is we tendered on a very large project, which is the Caribbean Cement Company. I remember, Maurice, the price was like 175 million US dollars for that upgrade. And it was kind of nerve-wracking for us. I recall we were doing the upgrade, which was built in several parts, which were built in several countries. Contractors, which ranges from Turkey, Japan, Germany, the US, Canada, Colombia, and Mexico. And we, and I think I missed one, Denmark, the peel contractors, and the overwhelming responsibility required that we look to Maurice Stoppy for assistance and guidance. And needless to say, we ended up in arbitration of some sort. We used the contract, which is the FIDIC, and it was a dispute which was resolved in our favor with much help from Maurice at the time. ADB Consultants is not new to this forum. We have been around, I think, since 1964, January, and we have spanned across the Caribbean, ADB Barbados, ADB Trinidad, ADB St. Kitts, and a few of the other islands around the Caribbean. I must say that it's a privilege for us to lend assistance where we can, and hopefully we will continue to do so in the future. I do not wish to take up much time, as we are just been given the privilege to say how grateful we are to the panel and distinguished guests, including ministers, Chief Justice, and retired judges. Let me, on behalf of ADB Consultants, congratulate you all for participating in this type of forum and giving us all the privilege to resolve issues in a way which is economical and forthright in all aspects of the game that we all play. Thank you very much.
Thank you, Martel, I know you're always a very comprehensive engineer, and I know that very well. So at this point, though, we're going to now turn over to Karen for the meat of the matter, which we're here about today. And what I'd just ask in the interim, though, is that those persons who may be on with phones that may be pinging, like, please put them on silent or on some other method which would not allow the ping to come through. Now, Karen Goff is from 39 Essex Chambers. Her profile, like all the others, appears on the coffeetimeiac.com website. She is preeminently qualified in the field and will take us through a program that I have been waiting for the last couple of months. Karen, the floor is all yours.
Good evening, everyone from London. First of all, thank you for the words of welcome from Chris and from the Minister and from Pat and Morris and just now Martel. Thank you all. Chris, please allow me, on behalf of everyone taking part, to thank you personally for your hard work in bringing us all together for this webinar today. If it looks easy, it's because you, with very able assistance from Nordia as ever, I'm sure, have done all the organisation. Turning quickly to the highlight of the webinar, the Maurice Stoppy Lecture, which is now in its third year. It is a particular pleasure to see Maurice, now elevated to the ranks of national treasure of Jamaica and the construction industry of the Caribbean, I think. See you looking so well, Maurice. Great to see you and to hear your words of welcome just now. I also would like to add my personal congratulations to Pat Cheltenham on his appointment as the incoming Chief Justice of Barbados. Well deserved. Many congratulations, Pat. Now, as the webinar explains, the title of the Stoppy Lecture is Courting the Court, zooming in on the role of the courts in the resolution of construction disputes. The issue for this evening's webinar is to examine and understand the extent that the role of the courts has evolved with particular reference to construction disputes. Has it expanded or has it reduced in the face of the increasing use of ADR and arbitration by businesses? In what ways does the court encourage or support the use of ADR or arbitration for the resolution of construction disputes? These questions and others are of real interest and concern to business, none more so than small and medium-sized enterprises wrestling to manage commercial differences and disputes in the face of limited resources and very often unequal bargaining positions. If we think that the resources of the courts and businesses were strained pre-COVID, the future presents an even more challenging landscape. What has been happening and what have we got to look forward to? It's now my pleasure and privilege to introduce my colleague and friend, the Honourable Mr. Wayne Martin, AC, QC, a distinguished jurist and the former Chief Justice of Western Australia between 2006 to 2018. He is going to give the lecture this evening. Prior to his appointment as Chief Justice, Wayne practiced at the Western Australian Bar in the field of commercial litigation, mainly involving disputes in the mining, energy, resources, construction, and financial sectors. His practice included international and domestic arbitration. As Chief Justice, he created and managed the arbitration list of the Supreme Court of Western Australia, and he has published many decisions in that field. In 2012, he was appointed as a companion in the General Division of the Order of Australia for his eminent service to the Judiciary and to the state's legal system. He is a qualified and experienced mediator and currently takes appointments as an international arbitrator and mediator, and he is much in demand. He also serves as part-time judge of the courts of the Dubai International Financial Centre at first instance and also on appeal. He's also a member of the National Sports Tribunal, Australia. So we are fortunate to have secured his agreement to be with us this evening. It is after 10 p.m. in England, but it is 5 a.m. in the morning in Perth, Western Australia. So good morning, Wayne. The virtual floor is now yours.
Well, thank you very much, Karen. A generous welcome. I'd like to commence by acknowledging all of our distinguished guests, especially, of course, Mr. Maurice Stoppy, in whose honour this lecture is being presented. Minister Charles, Chief Justice Designate Cheltenham, I wish you every success in your office in these challenging times, fellow panellists, and of course, all participants. It's a very great honour and a pleasure to have been invited to present this year's Maurice Stoppy lecture. My great regret is that I can't be with you in person, and that is because I've had a long-standing ambition to visit your beautiful island. To my great shame, that ambition remains unfulfilled, but perhaps when some greater semblance of normality returns to international travel, I'll be able to finally fulfill that ambition and come and meet you all in person. I'm also greatly honoured to have been invited to present an address in the honour of the exceptional contribution which Mr. Maurice Stoppy has made to the development of construction law and arbitration in the Caribbean. I'm sure that the breadth and significance of that contribution will be better known to all of you than it is to me. So I'll move on to my topic, which concerns the role of the courts in the resolution of construction disputes in 2020 and beyond. Of course, 2020 has been an exceptional year. It is the most exceptional year most of us have ever known, and very few of us have ever known a year like it. Virtually all aspects of human endeavour have been affected by the pandemic in all parts of the globe which we share. Construction work, construction disputes, and the courts are no exception to the effects of this pandemic. The construction industry has been dramatically affected. Lockdowns have affected construction work in many jurisdictions. The supply of essential materials has been disrupted, as has international trade. The supply of workers, both skilled and unskilled, has been affected. Greater attention has been given to force majeure clauses in contracts than perhaps ever before. And because of the economic downturn, cash has become king, and many parties simply can't afford the cost and the time involved in major dispute resolution processes. The courts have also been significantly affected, of course. Many of them in many jurisdictions have been unable to sit normally. Those that have been able to try and continue working have had to rely very heavily on technology of the kind that we're using this afternoon, and that has led to many backlogs and the delay in court proceedings. All of that has, I think, increased the emphasis on the need for dispute avoidance. As my mother used to say, an ounce of prevention is worth a pound of cure, or using a more contemporary metaphor, it's often said that it's better to put a fence at the top of the cliff than to put an ambulance at the bottom of the cliff. So how do we go about avoiding or minimising construction disputes? There are many ways, but I'd like to just suggest a few before turning specifically to the circumstance in which those techniques have failed. The first involves the use of clear and unambiguous contracts, particularly in those areas which most commonly give rise to construction disputes. We all know what they are. They include areas like latent ground conditions, where it's important to define exactly what is meant by the ground conditions, to define the state of knowledge at the time the contract is entered into so that we can readily identify when a condition is in fact unexpected or unanticipated, clearly identify the party at whose risk the discovery of latent ground conditions is to be borne, and the consequences of the discovery of those conditions. Extensions of time is, of course, another very fertile area for dispute and controversy. So the contract needs to clearly identify the circumstances in which an extension of time is justified, and most particularly how the relevant extension is calculated, because, of course, there are many different methodologies commonly employed in relation to extension of time. So it's helpful if the contract can identify the critical path, or at least the mechanism by which the critical path is identified, and the methodology which is to be used to assess the extension, and in particular whether that methodology is to be prospective in real time or retrospective to be reviewed after the event. There are also, of course, very commonly disputes with respect to variations. And so there needs to be a clear definition of precisely when a variation occurs, and also a clear methodology for the calculation of the cost of any variation. Moving on from the contract itself to my second issue, which concerns the fair allocation of risk and reward as between the parties. If one side uses its commercial strength or negotiating skills to procure a one-sided contract, which doesn't fairly balance risk and reward, the project is very likely bound to end in tears for both parties. Work will likely be disrupted by a long-running dispute, followed by a drawn-out and expensive legal battle, or the possible insolvency of the party who is disadvantaged, leaving the other party without a practical remedy and perhaps a partially complete project. The best price isn't always the best deal in the long run, and what you might save on price can quickly be eaten up by legal and other costs. The third way in which disputes might be minimised or avoided is the maintenance of good site records and communications utilising modern technology. In the old days of paper-based projects, there was perhaps some excuse for incomplete record keeping, poor communication, or the lack of a contemporaneous record. These days, of course, there are many proprietary software systems used for managing and recording events and communications on construction projects. One that in common use in Australia is a software product known as Aconex, which is very commonly used. This and other products can be very easily utilised in real time on portable devices such as a phone and leave an indelible record of what took place in all communications between the parties, which reduces conjecture when a dispute does arise. The fourth topic is the need for simple and clear dispute processes, provisions relating to the giving of notice of events that occur so that they can be addressed in real time rather than retrospectively months or years after the event. In the areas of common dispute, the areas I've mentioned like latent conditions, excuse me, extensions of time and variations. And the process needs to include procedures for responding to the notices within time. And of course, the parties need to follow the time limits. If they don't, and commonly they do not, then you get arguments about waiver and estoppel and things of that sort, which really are a distraction from the true issues. It's also important to clarify the role of the certifier in the construction project. Is the certifier truly independent, or is the certifier acting as the agent of the principal? So that's just a few thoughts about ways in which construction disputes might be either avoided or minimised. But if all that fails, then that brings me on to my topic, which involves the courts and their role in the contemporary ADR scene in relation to the resolution of construction disputes. Now, in Australia, and I suspect some other jurisdictions, the expression the multi-door courthouse has emerged to describe the contemporary role of the court. And it's already been touched upon by Chief Justice Designate Cheltenham. And what that expression is meant to convey, the multi-door courthouse, is a courthouse which serves as a kind of a triage centre whereby parties bring their dispute to the court, go in one door, but might go out another door using various alternative methods of dispute resolution, commonly described as alternative dispute resolution or ADR. So as I say, under that system, the court acts like a kind of a triage centre in an emergency department in a hospital. If you arrive at the ED and you're having a heart attack, the triage nurse will identify that and send you immediately to the cardiology section. On the other hand, if you've cut yourself, the triage nurse will send you off to wait, probably in a queue, while another nurse comes along and stitches you up. So the role of the contemporary court is to act like that nurse, to identify the nature of the dispute and the most appropriate way of resolving that dispute. Court-based options include mediation, and in my own jurisdiction of Western Australia, court-based mediation has been an aspect of all courts at all levels for about 30 years. In the Supreme Court, which I headed, we had 10 registrars, and about 60 to 80% of their time was spent undertaking mediations. They're all specially trained as mediators, and because of the nature of their work, they are the most experienced mediators in Western Australia. They're made available by the court at a subsidised rate, about $300 per mediation, which is very cheap compared to market price for non-court-based mediation. And the success rate is about 2/3 of the cases that they mediate. So about 2/3 of the cases are resolved by mediation, and mediation is in effect compulsory. So that, in other words, in my old court, nobody would get a commercial trial without having first gone to mediation, and 2/3 of the cases are resolved that way. And without that process, the backlog of cases awaiting trial would have basically drowned the court. And so it was an essential part of our capacity to keep up with the caseload, and it's worked very well. Other options available to the court include a court-appointed referee, so that the case can be sent out from the court to a referee. One of the advantages of that technique is that often you can identify a referee with particular technical skills. That can be important in, for example, a construction dispute that focuses on engineering matters. You might be able to find a qualified engineer and sometimes an engineer who's also qualified as a lawyer to act as referee. The advantage of that, as I say, is it brings to bear technical skills. It takes it outside the court system and therefore away from backlogs and delay. The disadvantage is that it makes an appeal from that decision very difficult, because unless there is an error of law, appeal is very difficult. There are, of course, many non-court-based systems of dispute resolution available in the construction industry. Many jurisdictions have this process of statutory adjudication, or sometimes called security for payment legislation. There's non-court-based mediation, where the parties can elect to go to mediation without being referred by a court. And of course, there are contractual provisions for things like expert determination and arbitration. Dealing firstly with expert determination, there are some advantages in the sense, of course, that you can appoint an expert who has the expertise in the particular field. It's usually an expeditious process, and it's a final process. So in other words, once the expert has determined, unless there's an error of law, that determination binds the parties. Of course, finality is a dubious advantage if you're the one who's lost, but it does at least provide certainty. The disadvantage of expert determination is that it's not governed by the law of arbitration, which can sometimes raise issues in relation to the extent to which the experts are obliged to comply with basic principles of procedural fairness, and also the extent to which experts are required to give reasons for their determinations. Another technique that is often used in very large projects concerns disputes boards. That is a board that's set up at the commencement of the project for the life of the project. The advantage of such a board is that it provides continuity and expedition, in the sense that the board is immediately apprised with the state of the project and can determine the dispute in real time and avoid disruption to the project by doing that. The disadvantage is the cost of setting up, if you like, a standing dispute board, and that's why it's a technique generally only used in very large projects. And of course, the other method of dispute resolution very commonly used in construction industry is arbitration. That generally requires contract, although the parties can, of course, enter into such a contract after the dispute has arisen. So the courts can have a role in encouraging parties to enter into an arbitration agreement. The advantages of arbitration are confidentiality, procedural flexibility, although for reasons that I'll develop, I think that can perhaps be overstated, given the procedural flexibility that now characterises the operations of most contemporary courts. The capacity to appoint an arbitral panel with expertise in the particular area of dispute, so that you can have a panel that comprises perhaps one or two lawyers, an engineer, and so forth. And of course, if the dispute has an international character, you get the availability of the New York Convention for the purposes of enforcement of your award, which is a big advantage as compared to a court judgment. The disadvantages of arbitration are, I think, the cost, because of course the parties are saddled with the additional cost of paying the full cost of the tribunal. Delay, if one party wants to drag out the case, and that's because arbitrators don't have the same coercive power of direction in relation to procedures as courts enjoy. And so I think while there was a time in which arbitration was generally regarded as speedier than court processes, I'm not sure that that's still the case, given the contemporary approach to court practice, to which I'll now turn. So where does litigation fit into this mosaic of alternative patterns of dispute resolution, particularly with regards to the construction industry? Well, the courts have come a very long way since the bad old days of Jarndyce and Jarndyce, described so eloquently by Charles Dickens in Bleak House. They've changed particularly since modern case management techniques have been introduced into most courts, and those techniques can largely be traced to the reforms pioneered by Lord Wolfe in the United Kingdom in 1998. Those reforms have been adopted in varying degrees and in varying measures in most courts in the common law world, and they have a number of common features. The first common feature is that the rules of court, the specific rules of court, are all subordinated to a common overriding objective. So in other words, all the particular rules are specified to be subordinate to and subject to the overriding objective, which takes precedence over any particular specific rule. The objectives identified in that override objective vary, of course, from court to court, but commonly they include the minimisation of cost, the minimisation of delay, the maximisation of efficiency, and the introduction of the principle sometimes described as proportionality. And what that principle basically describes is that the procedures of the court will be utilised only to the extent that the cost and time involved in the utilisation of that procedure is proportional to the dispute itself, that is to say, the value of the subject matter, and is proportional to the just and fair resolution of that dispute. So that if the dispute involves a relatively small amount in issue, the procedure to be adopted by the court will be tailored to reflect that fact, and substantial interlocutory procedures that would involve costs which are disproportionate to the amount in issue will be eschewed by the court. Another common feature of contemporary case management by the courts is what I might describe as tailor-made or bespoke case management. The Old English rules of the High Court, which many of us practiced under for many years, had a one-size-fits-all type of approach, so that every proceeding was presumed to require the same features in terms of pleadings, particulars of pleadings, discovery of documents, interrogatories, and the like. Contemporary case management techniques take a different approach and require the procedures to be modified to meet the particular circumstances of each case, a tailor-made or bespoke solution, if you like. And that is generally often conducted through what is described as docket-based systems of case management. The expression docket-based, I think, hives from North America, and it describes a process whereby cases are allocated to a particular judge when they enter the court. And the case remains under the supervision of that judge during its entire life, that is from inception to trial and disposition. The advantage of that is that the judge remains aware of the case. You don't get what is sometimes described as file churning, whereby different judges all have to become familiar with the case. So it's efficient. The other main advantage is that the parties know from the outset that the judge with whom they are dealing in relation to their interlocutory disputes will be the judge who will try their case in the event that it does go to trial. That has the beneficial effect of discouraging game playing, because parties know that if they behave badly during the interlocutory dispute, the judge will form a view about that in relation to their case, and that view might be brought to bear upon the resolution of their case at trial. The other advantage of docket-based systems is that it enables the creation of specialist lists, which are again a common feature of many courts. Lists are often set up in the construction area, the commercial area, the intellectual property area, and other areas of the court. The advantage of that is that it enables specialist techniques to be devised that are appropriate to the resolution of disputes in that particular area, enables the judge to develop expertise in that area, enables the practitioners to be familiar with the procedures that are likely to be adopted. And so docket-based case management combined with specialist lists is a very common feature of case management in many courts. Many of these procedures are aimed at, and a key focus of contemporary case management in the court is the early identification of the real issues in the case, not necessarily by pleadings. There is a tendency, I think, for the pleading process to involve a whole raft of issues which may not be central to the dispute. So the purpose of contemporary case management is often to get to the heart of what the real issues in the case are and eschew, if possible, all the peripheral or tangential issues. One way in which we endeavoured to achieve that in the court which I chaired was through a technique which we called the strategic conference, which we would convene fairly early in the life of the case. We set up the sort of system I've described, that is the docket-based case management system. And when we set it up, I thought I would do the profession a service by providing a set of standard form orders that could be used for the purposes of the procedural direction. So I published a practice direction which had 54 standard form directions with the idea that practitioners could choose from whichever of those directions were appropriate to the case. Unfortunately, I should have realised that what actually happened was that instead of exercising discrimination and choosing which of the 54 were appropriate, very commonly the practitioners would present to the directions hearing with all 54 included in their minute, and all they'd done is put dates in for the directions. They hadn't actually turned their mind to the question of which were appropriate to the case. So we thought, well, better get away from that. So what we will do is very early in the life of the case, we'll convene a thing called a strategic conference. It's a conference because it wasn't held in a courtroom, held in a conference room. And I've found, I must say, that the layout of a room does matter. If you put people in a courtroom, they tend to argue. If you put people in a conference room, they tend to confer collaboratively. And so the layout of the room I've found is very important. So we'd put people in a conference room, they'd attend with their clients, and we would workshop the case in a collaborative way in the presence of the clients. We would discuss the estimate of costs, how much the case was likely to take, and would discuss estimates of time in the presence of the client. And sometimes you could see from the look on the client's face that this was the first time they'd ever been told how much the case was likely to cost them or how long it was likely to take. We would discuss the key issues in the case, and the idea of that would be to build a strategic roadmap as to how the case would move forward. Conference would usually take an hour or an hour and a half, but at the end of that time, we would have, if you like, the strategic roadmap, a set of directions that would guide the future course of the case, and that roadmap would include the key milestones in the procedural process that would ensue, including, of course, mediation. As I mentioned earlier, mediation is an integrated part of practice in the court that I used to chair. And so it wasn't a question of whether you would go to mediation, the question was when. And so at that strategic conference, we would again discuss the most appropriate point in time at which to commence the mediation process, on the basis that we would ask the question, what is the minimum steps that need to be taken in order for mediation to have a realistic prospect of resolving the dispute? And that process worked, and I think continues to work very well. As I mentioned earlier, the docket-based case management, one of the features of the docket-based case management system is that there is basically no such thing as an adjournment sine die or an indefinite period of adjournment. the case would always be adjourned to be brought back before the court. And under this process, the court would take a much more active role in the maintenance of progress in the case than was the case under the Old English Court rules, where essentially the rate of progress was left entirely to the parties, and if the parties didn't open the door of the court would do nothing. Under most case management techniques, the court itself controls the process and the timetable and brings the parties back whether they like it or not. My own technique, in common with a number of other judges, was to conduct case management hearings in a conference room for the reason that I've discussed, rather than a courtroom, and to have a much more collaborative and cooperative approach to interlocutory procedures. Another technique we adopted was the active discouragement of interlocutory disputes. My experience in practice has been that interlocutory disputes consume amounts of time and money that are wholly disproportionate to their contribution to the just and fair resolution of the dispute. Days spent arguing about pleadings or the ambit of the discovery often have little or no impact upon the ultimate resolution of the dispute, but consume large amounts of time and money. One of the ways in which we actively discouraged interlocutory disputes was through a rule of court which required the lawyers for the parties to confer before bringing any interlocutory dispute before the court. And in a judgment, I interpreted the word conferral to mean a discussion between lawyers, each of whom had the capacity to resolve the dispute, not the exchange of furious emails, but a discussion, either by telephone or ideally in person, aimed at resolving the dispute. And if the parties did not undertake that, if the lawyers didn't undertake that process before bringing a dispute, one or both of them would be visited with the costs of the dispute. And that worked very effectively in getting lawyers to talk to each other. When we introduced that requirement, interlocutory disputes dropped by 1/3 almost overnight. So that, for example, we had, in any given year, we had about 6,500 interlocutory disputes. When we required the lawyers to confer with each other before bringing a dispute, that number dropped to about 4,000. So you can immediately see how much time and money was saved when you avoid 2,000 interlocutory disputes, just by a simple thing requiring the lawyers to talk to each other. Other techniques we used with interlocutory disputes were to introduce a requirement whereby the costs are fixed at the end of the dispute and have to be paid forthwith rather than put on the tab for payment sometime later. And we also provided the judges with a discretion not to hear an application. So an application was brought and a judge considered that the amount of time and money involved in hearing that application would be disproportionate to its contribution to a fair and just resolution. The judge could simply say, we are not going to hear that application, move on. And again, that was sometimes handy. And the other area I'd like to talk about is proactive. The other two areas I'd like to talk about before I throw it open to the panel is proactive case management in the two areas of practice that I think are essentially black holes for time and money, especially in construction disputes. And they are the areas of discovery or disclosure of documents and expert evidence. We all know that those two areas can themselves take on lives of their own and involve some very substantial cost and very substantial delay. So dealing firstly with disclosure of documents, of course, disclosure of documents is very much a common law process. It's not very well known or not a standard part of civil procedure, but it's part of common law process. It has, as I say, taken on a life of its own, and the nature of contemporary commerce is such that there are vast arrays of documents and therefore vast potential for dispute about the extent of the documents that can be disclosed. And it's not uncommon in major commercial disputes for issues with respect to disclosure to consume months, if not years, and many millions of dollars or pounds, depending on where you are. The sort of issues that arise in relation to disclosure are the time at which the disclosure disputes should be addressed, and in particular, whether they should be addressed before or after the exchange of witness statements. Most contemporary systems of procedure, like arbitration, perhaps following on from the processes that have evolved in arbitration, involve the mandatory exchange of witness statements at some point in the process prior to trial. So a question has arisen whether you have the disclosure dispute before, require the parties to make disclosure of documents before they exchange witness statements or after. The conventional approach, of course, has been that you deal with disclosure of documents before the exchange of witness statements, on the basis that the parties say, well, we need to know what the documents are before we commit ourselves to the provision of the evidence. The more recent approach that's been adopted in a number of courts in Australia is to require the witness statements to be served before any issues arise with respect to disclosure. That's seen to carry with it a number of advantages. The first is that the witness statements are likely to be more candid and more credible because they are based on the witness's state of information at the time the statement is produced or at the time the dispute arose. A witness statement produced after disclosure of documents has taken place is often augmented by information gained subsequent to the material time of the dispute and as a consequence of disclosure. So it becomes difficult to identify what was actually known to the witness at the time the dispute occurred and what's become subsequently known to the witness as a result of the disclosure process. So it's thought to enhance candour and credibility. It also avoids argumentative statements. So in other words, if the party providing a witness statement knows what's in the other side's documents, the witness statements tend to be argumentative and tend to address positions that are seen in the other side's statements, when in fact, of course, they should be restricted to the evidence that the witness is able to give from their own knowledge. The other great advantage of that process is that before you have any arguments with respect to disclosure of documents, you know what documents the party is going to be tendering, and so you have a database already upon which you can then formulate any subsequent debate about discovery or disclosure of documents. So you know basically what documents are common to the parties before you go into the question of what additional documents need to be disclosed by one party. So I think there is an increasing trend, certainly in Australian courts, to postpone issues with respect to disclosure of documents until after the witness statements have been served. And of course, again, one sees increasingly commonly court procedures being based upon techniques that have evolved in commercial arbitration. And those familiar with commercial arbitration will, of course, be familiar with the memorial process. And under that process, it's very common for the parties to put on their witness statements, the statements of case and the documents upon which they rely before there is any debate about further disclosure. And so the courts tend to be, in some jurisdictions, following that approach. In big cases, my own technique often would be in relation to disclosure to address that in a conference. Again, in a conference room requiring the parties to attend with their IT people so that you'd have their experts in present because, of course, in this day and age, virtually all documents exist in digital format. So you need the IT people to identify just how the documents are going to be retrieved. And you discuss in that conference setting the techniques that were going to be used, and in particular, whether the contemporary techniques, sometimes known as predictive coding or involving artificial intelligence, are going to be utilised. I don't know how familiar you are with those techniques, but basically they involve the identification of what's commonly called a seed set of documents. So the parties will identify, say, 100 documents that they agree are directly relevant to the issues in the dispute. And then the machine can be asked to identify out of another database of 1 million documents, which of the remaining 1 million documents most commonly identify, or most commonly have most of the features in the seed set. And you can set the filter at whatever level you like. So you can ask the machine to identify the next 1,000 documents that have features that most commonly resemble the seed set, or the next 10,000, or wherever you want to set it. And you can do that as an iterative process. And studies tend to show that these systems are more effective at identifying relevant documents than the conventional system of having paralegals sitting in a warehouse somewhere reviewing documents, because human beings are just not terribly good at identifying relevance. Their minds tend to be distracted by other things. So, and certainly those systems are much better than keyword search techniques. Any of you have been involved in discovery by reference to keyword searches find that they often produce keyword search based on a particular word will often identify more documents in response to the search than general discovery would. But the other way of using discovery is you use it to build a database. So in other words, it's not just the provision of disclosure. You build a database by coding the documents by reference to key fields, so that you have the key fields being usually the date of production of the document, the author of the document, the person to whom the person from whom the document emanated, the person to whom it was received, and the subject matter or heading of the document. If you have those data fields filled out, then you haven't just got a list of documents. What you've got is an interactive database that you can then use for the purposes of the hearing, so that you can then use discovery as a means of providing an investigative tool, a forensic tool that's available to the parties and to the court. But the key thing about the disclosure process is that it is an iterative process. So in other words, instead of just ordering general discovery by reference to the criteria in the famous Peruvian guano case, a very appropriate name for a case about general discovery, I always thought. But instead of that, you run it on an iterative basis, so that you spend as little time and money as you can. Then you ask yourself at different steps in the process whether the process has reached the point where you can not spend any more time or money on disclosure. The final topic I'd like to address, which is what I usually say when I'm about halfway through any address, is the topic of expert evidence. And again, this is another area which you would all be familiar with, can consume vast amounts of time and money. And the real problem with expert evidence is the common problem of the ships passing in the night, so that the experts don't engage with each other, and they're not addressing the same issues and they're not addressing the same topics. And that makes it very hard for the tribunal to engage with the different opinions. And of course, there's a real risk that if one of the experts or one or more of the experts provide their opinion on the basis of assumptions of fact that are not matched by the facts ultimately found by the tribunal, then the expert evidence may be of no value at all, despite the fact that large amounts of money might have been spent producing it. So again, in order to avoid that approach, a technique that I commonly used in court and I now use in arbitration with the concurrence of the parties is again to convene a conference of the parties to discuss a number of topics. Those topics include the issues in the case to which the expert evidence will go, the fields of expertise that will be engaged, the questions that are to be asked of the experts, so that the parties identify the questions they want to ask, unless there's a good reason. If any party wants to ask an expert the question, that question will go to all experts, so that all experts are being asked the same questions. The facts which the experts can safely assume are non-contentious for the purposes of their opinion. And then most importantly, the facts which are contentious. So in other words, the range of facts that the experts need to consider so that their opinion can address all the potential factual outcomes that might be found by the court or tribunal, so that the opinion is of value, whatever those facts are. And then there will be discussion about expert conferral. Most courts and tribunals now require experts to confer, usually in the absence of lawyers, and require the experts to produce a report identifying the matters upon which they are agreed and the matters upon which they disagree, with a short statement of the reasons for their disagreement. And there are nice questions that sometimes arise about whether that conferral should take place before or after they have written their reports. The advantage of conferral before reports is that you tend to find that the degree of agreement is significantly greater than after they've written their reports, although many lawyers are very nervous about letting the experts confer before the reports are written, because they're concerned the expert will have given the case away before the lawyer gets a chance to shape the report. But perhaps that's a good reason for actually requiring the experts to confer before reports are written. But most commonly, conferral will take place after the reports are written, and the combined report from the experts can then form the basis for concurrent evidence, or what's sometimes called hot tubbing, which is now the default position in most Australian jurisdictions, and increasingly I've found is the default position in arbitral tribunals. So the evidence of the experts is given concurrently. All the experts are sworn at the same time. There's an interactive process of questioning from both the lawyers. The experts can question each other, and the tribunal is actively engaged in the process. And I found that's very effective in enabling the tribunal, the court, to identify what the real issues between the experts are, and then to enable you to form your own view about where the resolution of those experts lie. So in general, with the introduction of those sorts of techniques, with the contemporary case management techniques, you can see that contemporary courts are very competitive with arbitration in terms of the flexibility of process, driving the process to ensure expeditious outcomes, to avoid unnecessary interlocutory disputes, to focus on the real issues and encourage the parties to arrive at a consensual resolution through the process of mediation where at all possible. So I think contemporary courts are very, very different to the sorts of courts that we've heard historically. And I think with these sort of techniques have a very real and important role to play in assisting parties to resolve their disputes. And that is all that I wished to say. I think I may have gone a minute or two over time, for which I do apologise, but that's all I wish to say. Thank you very much for your attention.
Wayne, thank you very much for that very stimulating lecture. That's given us lots to think and talk about. Can I go straight to a plug for one of our sponsors? I'd like to introduce Nadine Pottinger, who's a VP, EBD Sales and Marketing of the Guardian Group. Nadine.
Good afternoon. It's Assistant Vice President for Employee Benefits, Guardian Life Limited, distinguished panelists. Good afternoon. Guardian Life is pleased to be associated with and to sponsor this Jamaica International Arbitration Center Limited's webinar. I bring you greetings on behalf of our company president, Eric Hossein, and wish you all the best in this important seminar as we seek to make the resolution of disputes and the use of arbitration even better. Do have a wonderful seminar.
Nadine, thank you very much indeed.
Thank you.
For your sponsorship and also for your welcome and encouragement with our webinar this evening. So can I move very quickly into our panel discussion on the issues that Wayne has raised in the lecture and on their own personal insights. Could I remind everybody of the ability to pose questions through the chat mechanism on the Zoom? You just type your question in and we'll try and pick them up and field them into the discussion. Your questions will be very welcome. And what has happened this evening is, given that we also have Pat Cheltenham QC, the incoming Chief Justice of Barbados, with us, we might even inveigle him to join the conversation or during the question and answer session. So if you have a question for Pat, do send it in. Rarely will you have had the privilege of seeing 3 Chief Justices, 2 former and 1 incoming at the same event. And we're very pleased and proud that you see them here first. I want to start, however, with my first 3 panelists, Paul Sandosham, Aisha Nadir, and the Honourable Justice Zela Mccalla, and invite each of them to say a few words about what they have heard in the lecture and how this ties in with their own experience. You will find the CVs of each of them on the website in connection with this event, so my introductions will be very brief. Firstly, to Paul. Paul is dual qualified in the UK and Singapore and a leading dispute resolution practitioner in Southeast Asia, where he heads the Energy, Infrastructure and Resources Disputes practice of Clifford Chance. He has the benefit of being both a litigator in Singapore, a party representative in domestic adjudication proceedings, a board member in international adjudications, dispute review proceedings, and also counsel and a well-known arbitrator in international arbitrator. When we think of Singapore, also a common law jurisdiction, there is a general view that Singapore is very much up to speed with the techniques for the resolution by litigation or ADR or arbitration of construction disputes. Within the panoply of dispute management and resolution tools, we see that the Singaporean court's role is both defined and really very effective. So to Paul, what would you say are the key features of the Singaporean court system which are directed to supporting the effective and efficient litigation of construction disputes or supporting their resolution through arbitration or ADR? Paul, please.
Thank you, Karen, and thank you for the privilege to be on this panel together with such distinguished panelists. I'll just say a few words of the Singapore experience from the perspective of a practitioner and arbitrator dealing with construction disputes. And I would say there are 2 areas that Singapore has developed to assist in the resolution of construction disputes. And the first is the judiciary, We have highly qualified judges in the courts. And while we do not have a TCC or technology and construction court like in London, we have specialist construction judges who are appointed to hear construction cases. So we have a docket-based system as described by Wayne Martin earlier. So the judge deals with the matter from commencement all the way to trial. And many of the judges appointed to hear construction cases were themselves active construction practitioners before being elevated to the bench. So they understand the concepts in construction disputes and are familiar with the techniques to use in resolving complex construction cases. The second area where we've seen significant development is raising the standard of the bar. About 3 years ago, the Singapore Academy of Law came up with an accreditation scheme to recognize practitioners who had experience in acting for parties in complex construction disputes. And I think this arose out of a concern that some advocates were not familiar with basic construction concepts in court or did not know how to use Scott's schedules or mechanisms such as hot tubbing of experts to resolve construction disputes. And I think the courts took the view that it would be good to implement or come up with a system where lawyers who are experienced or experts in construction disputes could present the cases in court and they could be accredited. So there's quite a stringent application process to demonstrate one's expertise in handling complex construction disputes, and it includes an interview before a panel of judges. There's a senior category of which I'm a member, and there's also a junior category to encourage young practitioners to specialize in dealing with construction disputes. And for the junior category, unfortunately, there's a rather difficult examination that they need to pass. I think they exempted the older generation from the examination, knowing at this age it's not easy to deal with examinations. Now, this obviously benefits the end user, who then has the comfort of knowing that the lawyer he or she appoints has the competence to help him or her present the case in the most cost-efficient way. And as we know, construction cases tend to be quite expensive. And I think getting the right lawyer to present your case, who understands how to present your case to a tribunal judge, will help a lot. I mean, the other 2 points I would mention are that first, we have a very well-developed arbitration and adjudication regime. By and large, most construction disputes are resolved by way of arbitration. And I think most of you would recognize that Singapore is now sort of the leading hub for dispute resolution in the region. But that's just one part of it, because arbitration can't succeed without the support of the courts. And we have a very supportive court system as far as arbitration is concerned. There are limited grounds to challenge an award, and the courts rarely intervene to set aside an arbitral award. The other part of the dispute resolution process, which has grown tremendously in Singapore, has been adjudication, and this has been very successful in helping cash flow for builders. We have been, in some ways, grateful to the Australian experience in that we adopted pretty much wholesale the New South Wales legislation on security of payment, and therefore the judgments in the New South Wales courts have been very helpful where disputes arise in terms of the interpretation of the Act. Now, the Act itself does give teeth to adjudication determinations. For instance, adjudication determinations can be enforced in the same manner as a judgment or order of the court. And also, there are provisions in the Act that allow a party who has not been paid the adjudicated amount to lawfully suspend work. So there are these self-help remedies. It's not just a piece of paper. There's serious teeth and sanctions if a party doesn't pay up. The counterparty doesn't pay up on an adjudication determination. So I thought that sort of brought a useful sort of summary of the perspective and what we see from the Singapore experience. And perhaps it'd be interesting to hear from the other panelists from their own jurisdictions.
Thanks very much for that. With Stoppy, the Singaporean experience, can I quickly turn now to my second panelist? Aisha, it's a pleasure and a privilege to invite Aisha to speak to you this evening. She holds a Bachelor of Science degree in Electrical Engineering from the University of Nebraska, an MBA from the University of Texas, Austin, Texas, and an LLM in International Commercial Disputes Resolution from Queen Mary University in London. So she certainly has been educated on a regular basis, and that comes through in what she contributes to our panel discussion this evening, I am sure. She acts as arbitrator, mediator, adjudicator, and dispute board member, and has experience as president institutional rules. As a member of the FIDIC board, this evening, she was responsible for the contract in 2016 and 2020. She's on a panel of theaters of Exit and the FIDIC president's list. I should therefore, as I say, bring a unique and different perspective to the discussion. I invite Aisha now to address briefly on what in her view are practitioners. Mediation, construction disputes, and dispute avoidance with arbitration have their own place in the construction dispute.
Karen, I'm not hearing you. Is it just me or is it everybody? I'm not hearing Karen well.
Yeah, Karen, you're coming up very muffled.
Not hearing. Not
and,
hearing.
Hello?
Distorted.
Yeah.
The sound is distorted.
You sound a bit like Darth Vader.
Well, that would be good. Can you hear me now?
Your
Not-
voice
not
is
well.
quite distorted.
Yeah.
Which I can understand, but
Karen, we're still not hearing you.
Karen, we're not. Karen, we're not hearing you. Perhaps what we will do is ask your next speaker, who I think is Aisha, to make a contribution.
carry on.
Thank you, Karen. I will try and answer following on from Wayne's presentation and Paul's. And I don't know. I understood what you said, Karen, because when you introduced me, I know what education I have. So I'm one of these crossbreed people. I'm an engineer who then transferred into the law, and I also sat on the FIDIC board, responsible for the contracts committee. And Wayne had started his lecture talking about his mother saying prevention is better than cure, and I was caught by the building the fence on top of the hill as opposed to having an ambulance at the bottom. And I think one of these things is FIDIC in the contracts. I heard Martel talk about that he had a FIDIC contract. It is within the construction sector. It takes partnership for purpose from the inception of the contract all the way through, hopefully, successful project execution. And I think the role of the courts, if we're talking about ADR, is really from a practitioner's perspective, and I say a practitioner possibly participating in construction, is having confidence that the courts will support an agreement to ADR if within the contract. So I'll use FIDIC contracts as an example. Wayne had indicated risk is inherent in every step of the way, and having a contract that addresses risk and reward. Well, it is the corollary to that is having a stepped dispute resolution mechanism, or having contractual access to ADR. And FIDIC approaches that by having a multi-tiered dispute resolution process that includes specifying the engineer's role in both as a certifier and as a dispute resolver. engaging a dispute board as a second tier with more of a neutral function. And then the ultimate view is the ultimate recourse to arbitration. And like Paul had said, having a court that supports agreements to engage in alternate dispute resolution provisions. So, and also a court that supports or enforces decisions that result from those alternate dispute resolution provisions. So it would be very important to focus from a development perspective, engaging SMEs and ensuring that the court supports both the agreement to engage in a multi-step dispute resolution process and provides the support in enforcing the decision at the back end. So I'll stop with my comments there, Karen, and turn it back to you. Is your microphone working now?
Karen, it appears not to be working. So I will thank you, Aisha. And the next person we would like to have some comments from is retired Chief Justice of Jamaica, Justice Zela Mccalla. She is a very distinguished jurist and who, notwithstanding her retirement, continues to be of significant service to the nation, and including in many ways. And while as Chief Justice, she introduced several significant initiatives in the court, including her push for the greater use of ADR and some supporting administrative structures that she would have put in place. And having no idea of what it is that Karen intended to do by way of introduction, I will merely say that all the details, as Karen has said about Justice Zela Mccalla and all the other speakers, can be found on the website. And I now turn over to Justice Mccalla for her views on the matter coming out of the lecture.
Thank you, Dr. Malcolm. May I take a minute as well to welcome all the participants locally and internationally. We live in hope that at some time in the future, we'll be able to have an in-person conference where we could welcome you all, you know, with our warm Jamaican welcome. Now, the lecture is in honor of the distinguished Maurice Stoppy, and I'd also like to congratulate him and thank him for the magnificent work that he has done, not only in the field of arbitration, but in several other areas. I thank the panelists for their insights. And I must say that even though I'm retired, I have an abiding interest in the continued access of justice and also in upholding the rule of law in our country. I would like to say as well that I embrace this broader concept of dispute management on which focus is now being placed. It is also critical for the quality of life of our citizens as it relates to our interactions with one another, both personally and professionally. Now, if the court is to fulfill its constitutional mandate of delivering fair trial within a reasonable time, then the most effective and speedy mechanisms must be employed to divert cases which may be resolved by other means. Now, I thank Chief Justice Martin for the many insights that he has provided, and he has made reference to several initiatives that I believe could be usefully employed in our court system. Now, it is timely really to have this discussion, bearing in mind this global pandemic, which has affected all of us, not only in terms of our personal interactions, but also in terms of the way that we work. So we have to consider how best to use our judicial resources to facilitate not only the resolution of this construction and other disputes, but also to avoid disputes in the future. Now, in our jurisdiction, we have had a commercial court now for nearly 2 decades. And I must say, at first it was being underutilized, but at present, we have specialist judges, and we also do have, as features of the court, a case being tried by one judge, being dealt with rather, by one judge from its inception to its conclusion. Cases are dealt with quite expeditiously in that court, and we have a high percentage of hearing date certainty. There's also the use of technology. But I must say that construction cases would properly fall within this court. One cannot help but know the increased activity in building, especially in recent times, because as I've heard that in some cases, building activities have toned down. It seems as if in our jurisdiction, it has increased. We note as well with the advent of COVID, you will have perhaps the breakdown of more contracts because of the unforeseen circumstances which this disease has brought to us, not only in Jamaica, but globally. And so these matters could result in even greater pressure on our court system, so that we have to place greater emphasis on proactive case management. And this is where some of the insights provided by Chief Justice Martin, I believe, could usefully be deployed in our court system, and he has mentioned several of them. Now, we are at a stage where I believe the provision of on-site facilities for cases to be mediated could also be employed. And perhaps we have to bear in mind as well that the case we do in our jurisdiction, we have mandatory referral of civil cases, referral for alternative dispute resolution. The process sometimes takes very long, and this is an area that we have identified for some improvement. Now, in the management of disputes, a procedure could be put in place for trained court personnel to identify relevant issues that could have the effect of avoiding or minimizing breakdown in contractual relations, and of course have a method of dealing with this. And I believe that it was Chief Justice Martin who mentioned this triaging of cases that is triaging procedure that is known in the medical profession. So that in our context, I believe that because we have a lot of disputes that often result in criminal offenses being committed, it is of very great importance for us to really look at the alternative methods of resolving cases. This would play a leading role in our justice system, and it would also be necessary for not only court personnel to be educated on a continuing basis regarding the alternative mechanisms that could be employed, but also for other participants in the justice system.
Yes, I think Karen's mic is okay now, so I think she'll take back over.
Yes.
I think so. Can you hear me?
Yes, you're now being heard.
Ah, great. Okay, I'm sorry about that. I logged back in and it seems to be okay. Zela, I'm really sorry I wasn't able to introduce you. I was going to say the woman that needs absolutely no introduction.
Chris did
have one.
Good job.
He did. So thanks very much to Chris for that. Right, so the panel discussion is now open for questions. I can't see any coming in particularly, but could I ask the Chief Justices, so Wayne and Zela, and certainly Pat, if he'd like to contribute, focusing on the role of the court and picking up on the themes in Wayne's lecture this afternoon. One of the things I noticed particularly was his preference for conferences rather than court-based hearings, which struck me as a really good idea, and something, of course, which is widely practiced in arbitration, even if under a different sort of name in terms of meetings. I wonder whether that's something that that is something. Oh, somebody's just said to me, look into the question and answer for questions. No, okay, I've got that. But I wonder whether that's something that would be feasible and or of interest to the region, to the Caribbean region, and indeed perhaps also address that question to Paul, how the courts of Singapore might look at that. So Wayne or well, Zela, perhaps you, what do you think of that?
Yes, well, as he spoke about the question of discovery and how it is approached in his jurisdiction, as well as the conferral, I think conferral is what Wayne made mention to, so that issues could be agreed on, and you could have as well, in the case of experts, you could agree on certain areas so that at the end of the day, it could shorten trial and save expenses. He also, the strategic conference is another area. I think the other one he mentioned was the expert conference that was specifically in relation to experts and the approach in his jurisdiction. But I think the strategic conference is also very important and is something that could easily be implemented in our jurisdiction. Active discouragement of interlocutory applications is another way in which, you could control the behavior of the parties and seek to shorten trial if the matter eventually goes to trial.
Thanks for that. Paul and Aisha, I mean, my experience is that it's commonly a game of tags between the commercial courts, or in my jurisdiction, the TCC, and International Arbitration Tribunal. They seem to feed off each other in terms of procedural developments. What's your experience of this? Paul, what would you think about conferences rather than applications in the Singaporean court? Culturally, is that something which would work well there? And then after you, perhaps Aisha could add some comments as to how she sees this playing out in dispute review board proceedings and in arbitration. So Paul, first to you, then Aisha.
Well, thank you, Karen. Yes, I mean, it was a rather interesting observation from Wayne about how you can encourage parties to be less adversarial by putting them in a conference room as opposed to a courtroom. I mean, I'd be quite interested to hear from Wayne whether you, in the Western Australian courts, whether you had specially built conference rooms for the purposes of those discussions. I mean, I think it does probably work. I think the environment parties are put in does influence the way they behave and conduct themselves. I mean, I guess in our courts, the judges simply have their own chambers and the courtroom. So I think the options for a conference room are quite limited. But I tend to agree with Wayne. I think if you have a different sort of environment, I think it creates a different sort of attitude among the parties. But yeah, an interesting observation there.
Paul, perhaps I could answer that question. As it happened, we built a new civil commercial court building for the Supreme Court during my term. And a few years after, we'd introduced this practice, and I was in charge of the design. And next time you come down to Perth, Paul, I'd love to show you over it. But as you might guess, because I was in charge of the design, we've got more conference rooms in that building than we have courtrooms. And we use them because we have a lot more case management hearings than we do trials, and so and a lot more mediation. So we've got 2 floors of that building are devoted to mediation suites, and we've got about 10 mediation suites. We've got about 20 conference rooms, and I think we've got 12 courtrooms. So, and that reflects our practice. We have, because of our case management processes, we have very few trials, and there's a phenomenon known in Australia as the disappearing trial. Young lawyers are very concerned because they don't get trial experience, because our case management systems basically weed them out and get rid of them some other way. But happily, we've just built a new building that reflects contemporary practice, which is great.
Oh, that's fantastic.
Great. Aisha, what do you think about this?
Well, I actually think your idea is we all have to learn from each other, and we kind of go back and forth. And one thing that I think I heard Wayne saying was at these strategic conferences that the parties, not counsel, not only counsel, but the parties are actually there. And I think more alongside being in a conference room, having different people at the table also changes the dynamic. Because coming from the engineering side, I think when you look at a lawyer's approach to solving problems, lawyers tend to resolve disputes by controlling data and debating and arguing about that data, whereas the scientists or engineers may put the data on the table and have more of a discussion about what that data actually means. So I think having the construction professionals all at the table will facilitate having a dialogue and maybe getting to the real issues and coming to a cost-benefit solution. I think one of the comments that Wayne said at the strategic conference was the first that the parties actually heard the real cost of addressing their dispute. And I think when you get to know the real business case, the decision may be a bit different how you're going to pursue that dispute. So I think learning from each other and sharing experiences and making sure that the right people are around the table when you're deciding the path forward or the roadmap is quite important.
Thanks, Aisha. Yes, absolutely. Making sure the right people are in the room, the people that can make decisions, is really very important indeed. Pat, you didn't sort of wave at me. I have got you on my screen. Did you want to make a contribution on that point?
I wanted to ask Wayne what is the nature of the fundamental reform carried out in relation to the case management, whereby they can affect so many radical changes. That really does fascinate me.
Well, sure. Thanks, Pat. Basically, we rewrote the rules and we created a specific case management rule. And the first rule, and we introduced the overriding objective rule that you see in many rules, that is that the fundamental purpose of all of these rules is to achieve an efficient, fair, just resolution of the dispute at the most reasonable price. And so that's the overriding objective. And then the first rule in our case management rule was that the case manager can do pretty much anything he or she likes in the furtherance of the overriding objective. So there's a general discretion to the case manager to do whatever they want in the interest of the overriding objective, and then we give specific examples of the way in which that can be achieved. So in other words, it's really taking the docket-based management system that I believe I've not just heard you have in Jamaica, and empowering the judge to take control of the case and to use whatever technique they think is most appropriate. And we accompany that, the Court of Appeal over which I presided, basically had a hands-off approach in relation to interlocutory appeals, so that we would back the judges to do whatever they thought was appropriate and not interfere. And in that way, we would encourage the judges to innovate, to use new techniques. Not all judges adopted the sort of techniques that I described. I'm a bit more interventionist, I think, in approach than most judges, but it's empowering the judges and backing them to use their discretion and their experience to bring forward new techniques and to bring the parties along with them. And I think that was the key to it. And again, learning from experience, some of the things I mentioned, the postponement of discovery until after witness statements, that was pioneered in the Commercial Court of New South Wales. And I heard about it and thought it was a good idea. So we embraced it there. And we have a lot of interchange with our colleagues in Singapore because we're geographically close. So we learn a lot from each other. So it's really an intercollegiate judicial process of learning by experience. But it's fundamental empowerment within the rules of the court, backed up by the courts of appeal.
That's really interesting. Thanks. Thank you both for that. In fact, the ability to effect major changes without the need for primary legislation is one of the things that's of real importance in all of this. I think Chris wants to ask a question of Wayne, and then I'd like to go to the Q&A questions, because we now have a number of those that people have asked, and it'd be good if we could answer them. So Chris.
Thanks, Karen. Wayne, Justice Mccalla just mentioned a little earlier that one of the problems we have in the case of Jamaica is that we have an overwhelming number of matters on the criminal side. And the question, I suppose, that flows naturally from that is whether, as we look at this multi-door court facility that you're talking about, we should perhaps consider using much more of the public law type resources in the context of the court, trying to deal with those, and more on the private law side through the ADR, a properly managed ADR process. And that's one thing. And the other question is how it is that you were able to convince your judges and the court system more generally there to come along with you on that journey that has resulted in the disappearing trials, as you mentioned it.
Well, dealing with the second question first, Chris, it was very interesting because and this might be interesting to Chief Justice Designate Cheltenham, but what I found when I was appointed was you get a kind of a honeymoon period with your judges for the first 2 or 3 months when you're a new Chief Justice. And so I went around and spoke to them all, and we had 24 judges, I think, on the court. And I went and spoke to them all, workshopped the ideas with them. And then we had it set aside 2 days for a judges meeting, and I outlined the blueprint for where we're going forward, and they all agreed with it. So I think that was before they'd had time to know my foibles, my inadequacies, and that stage they still trusted me. So I think it's important to strike while the iron is hot, as it were. But getting back to your point about the balance of criminal and civil law, we of course have the same issue in Western Australia, and we had a lot of resources were being applied to crime. But interestingly, we also applied some of the techniques that I've described to our criminal caseload. So we have a system, we don't call it mediation, but we call it criminal case conferencing. And so we would have, again, for every trial in the Supreme Court, there would be a criminal case conference, which would be a quasi-mediation in a criminal case. It wouldn't necessarily be aimed at producing a plea of guilty, but often it would. We'd discuss the question of whether the charge could be downgraded in return for a plea of guilty. We don't have plea bargaining of the kind in the US, so we can't agree sentence, but we could agree a downgrade of a charge, or we could agree upon what issues really were in dispute so that the defendant, the accused person, might be prepared to agree certain facts which could have a dramatic impact on a trial. I remember one case, big white collar case, listed for 3 months, sent it off to criminal case conferencing, and the trial length came down to 2 days. Because everybody agreed what the facts were. So I think there is a role, a more limited role, but there is a role certainly for proactive court case management and even ADR type processes in criminal law. But what we tended to do was we kind of had divisionalisation so that we had the civil judges and the criminal judges. And so the resources on the civil side were basically made available. If you're short of resources, you can outsource the ADR, you can outsource it to the private profession. The disadvantage of that is that it's a lot more expensive. And with our court-based mediation, it's a lot cheaper. And also we were able to control the delay, so that I made sure that at all times, basically, we could offer a mediation within about 6 weeks. So if somebody wanted a mediation, we could have a registrar available for them within 6 weeks' time. And on the basis that it saved us a lot of money. The sooner a case settled, the sooner the court saved money. So I don't know, does that answer? You had a number of questions there, Chris. Does that cover them all?
Yes, Wayne, thanks. Yes, certainly.
Great, thanks very much. Well, can I take some of these questions on the question and answer now? And I've got one from Keslin Gilbert. And Paul, can I address this one to you? It says, do you find that in relation to these disputes, the binding nature of the ADR processes, so obviously not all ADR processes will be binding, or certainly not final, whether that is problematic and may discourage the use if not specifically provided for in the contract. So Paul, what can you say to that?
Well, I thought one of the attractions of ADR, I mean, especially arbitration, was the finality of the decisions, where the scope for challenging is much more limited compared to the court process, where there could be multiple rounds of appeal. An arbitration award is pretty much final, and I know the New York Convention, which sort of 162 countries are signatories to, they're limited grounds of challenging the award, and they're pretty much based on sort of breach of natural justice or breach of procedural issues, but the findings on the merits stand. So I thought that was one of the attractions of ADR in the perspective of arbitration, where you don't have the opportunity to sort of reopen the issue. Yes, you may not get the outcome that you want ultimately, but that's one of the risks of arbitration, but it works both ways. But there is finality in terms of a decision. And in some ways, with arbitration, you choose your tribunal. So if it's a construction dispute, you choose the individuals you want to hear the dispute, whether they be engineers or architects or quantity surveyors. They make a decision and you sort of live by whatever they come up with. So, I mean, that's my observation. So I wouldn't see it as a discouragement or a downside. I think to some it is a positive, having that finality of decision. And I think if you speak to a lot of end users, I think the sort of the complaint about arbitration, yes, is that it just takes too long. But I think what parties want at the end of the day is a decision either way, right? Rather than this sort of things are kept in abeyance where they don't know what their rights and obligations are. I think they just want a decision and get on with it. I think that if they've taken surveys from general counsel, I think that's one of their preferences. They want a quick decision either way. And then so they can get on with the project and get on with life.
Thank you very much, Paul. Next, if I could just field this to Zela, I think I'd like to field it to you. I'm sure you have the answer. And this is from Dean Burrows. Good evening, Dean. How would you suggest, he asks, we improve the appreciation of arbitration and adjudication in the courts, since these proceedings cannot succeed without the support of the court? You need to unmute.
The first aspect of the question.
How would you suggest we improve the appreciation of arbitration and adjudication in the courts? And the second is because he says these proceedings can't succeed without support from the court.
Well, certainly in our Jamaican jurisdiction, we don't have that many cases dealing with arbitration because of how strict the rules are in relation to that. But in relation to adjudication, I think that the main thrust ought to be to employ as many methods as possible so as to avoid delays really in costs and waste of time. I don't know if that answers his question.
I think also, and certainly when speaking to you earlier, Zela, you were very emphatic about the need for education of all stakeholders in the processes, not just of the court, but also in arbitration and adjudication, and starting, I think, with judges and going down through the lawyers and, of course, to the parties.
Yes, well, I believe that is important for everyone to have buy-in in the system. I'm particularly intrigued by the situation in Australia, where you have more court rooms, more conference rooms than courtrooms, because I think it sends a strong signal that the court is not only a place where you come to have cases tried, but you come to have cases resolved by whatever means necessary.
Thank you very much, Zela. And if I pick, perhaps, because we're running out of time here, just one final question, and he refers this to Wayne. He says, you made mention of increased disputes due to COVID and the possibility of insolvency of one or both parties. due to the adverse economic effect on delays in resolution. I don't know if you can do this shortly. Any recommendations, he asks, on the way in which, or the way in which a party who feels as if they have less power in a dispute and may not be able to wait out a delay can get a matter on for resolution quickly and fairly?
Okay, well, the quickest way of resolving a dispute and the cheapest way is by mediation. And so if you go to either court or to arbitration, you're talking about years and a lot of money. So mediation is the quickest way. If you've got if you have court-directed mediation, if the other party won't agree to mediation, if you go to a court and ask the court to direct mediation, and I understand in Jamaica that's available. Chief Justice Mccalla referred to mandatory mediation. And of course, it's often said that in a mediation environment, there is a power imbalance, and so that there is a danger that the powerful party will be able to override the less economically powerful party in a mediation context. That is where I think the mediator comes in. It's very important for the mediator to protect and preserve the integrity of the process and to ensure that economic power is not used and that the dispute is resolved fairly with regard to the balance of rights. But really, I think that in practical terms, the only alternative to a fairly lengthy process is mediation. And so if you can't agree to go to mediation, go to a court and get the court to direct mediation is probably the best way about it.
I think we'd all agree that that's a good answer, Wayne. Thanks very much for that. Okay, we need almost to sign off now. In fact, we do. In 30 seconds, can I ask each of my three panelists and you, Wayne, and Pat, if you have anything, a 30-second takeaway for the attendees of this meeting. Let's start with Paul.
Okay. I had a takeaway I wanted to give, but I thought I just mentioned, I think the elephant in the room is what the future of dispute resolution, especially for construction disputes, going to look like going ahead. I think with the COVID pandemic, I think we have to accept that virtual or remote hearings is going to be the new norm. I think just one comment is that I think many arbitrators are saying that the need to physically observe the demeanor of a witness to ascertain if he or she is telling the truth is simply overstated. So I think we're just going to have to get used to having hearings remotely, because who knows when we'll be able to travel next. So something, food for thought, and perhaps something to discuss at the next discussions or seminar.
Excellent point. Aisha. Where did you go?
Yes, she needs to unmute.
Yeah, Aisha, unmute.
I'm unmuting. Sorry about that. With COVID, I think we have to, the realization is that we have to partnership. We have to partner for mutually assured success or mutually assured survival, more like. And we will have to raise issues and focus on collaborative means, either mediation or some sort of negotiation early on, as opposed to turning to a third party, if possible, to resolve your dispute, to facilitate it and reach agreement.
Thank you very much, Aisha. Zela, what's your takeaway?
Yes, well, I am still so much intrigued by the approach in Australia and what can be accomplished. And I believe that it is something for us to consider implementing a lot of what has been suggested in that jurisdiction. And in a situation where resources are scarce, I think it is more important than ever so that we pursue all methods to have training of our judges and other stakeholders so that they can buy into this whole new dispensation of the effective management of cases in our jurisdiction, so that our courts will become more efficient and people will have greater access to justice.
Thank you very much, Zela. Wayne, any last word from our lecturer today?
Just very quickly, COVID has shown how unpredictable the future is and how we must retain innovation and flexibility to deal with the unexpected. And I think in this context, that means that we must be innovative and flexible to focus upon outcomes, and outcomes that suit the interests of the clients and the justice of the situation, and don't focus too much upon the interests of the legal profession.
Wise words indeed. Well, can I thank you all very much indeed for sharing your collective expertise with us this evening. Thanks again in particular to Wayne, and thanks also to Pat. We wish you success in your new role as the Chief Justice of Barbados, and we hope we've given you a few ideas to go forward with this evening. I'm now going to hand back to Christopher Malcolm, or I think we have a sponsor. Chris, would you like me to hand over to Mr. Hay?
Yes, you may, Karen, yes.
Well, could I please invite Mr. Hay, Managing Director at CPM Consultants, one of our sponsors this evening. Good evening.
Good evening, everyone. Thank you very much, Karen. First of all, I'd like to say thank you to all the members of this distinguished panel. It's quite an interesting discussion. Thank you for your participation as well, and for all the attendees. Here at CPM Consultants, as dispute resolution practitioners, we are quite happy to be part sponsors of this event. We believe that events like these are very important. The conversations themselves serve to encourage the flow of ideas, the exchange of best practice, and would foster greater understanding not only of the utilization of ADR mechanisms in settling construction disputes, but also to aid in the discussion regarding the avoidance of construction disputes through better administration of construction contracts. So we look forward to continue to supporting Chris and his team at the Jamaica International Arbitration Center. We believe that they've done a marvelous job with this Coffee Time series, and we look forward to continued support. And we'd also like to take the opportunity to recognize Stoppy, one of our own, whose contribution to the development of the quantity surveying profession, Jamaican construction industry, and the practice of arbitration for the resolution of disputes in construction contracts is undoubtedly without equal in the industry. So again, thank you all very much, everyone, and do continue to enjoy the rest of this proceeding.
Thank you very much, Dada. Chris, can I hand the proceedings back to you now?
Yeah, thank you, Karen. And before we get to the vote of thanks, we have another sponsor's plug that we need to be getting from Petal James, who's a chief of branches of Jamaica National Bank. She is among the several sponsors, and we now hand over to you, Petal, for your words. Petal, please unmute yourself so we can hear you.
Okay, good afternoon, everyone. I'm so sorry. My internet connection went, so I had to use my phone to tether to come back with you. So I'm sorry if I missed you with the introduction. I'm so sorry, Doctor. Good afternoon again. Our Honorable Justice Zela Mccalla, former Chief Justice of Jamaica and Commissioner Electoral Commission of Jamaica, Ms. Aisha Nidar, Advocate Furman, Rudland, and member of American Arbitration Association, ICDR Council, our moderator, Ms. Karen Goff. Ladies and gentlemen, good afternoon. This is an interesting and delightful way to discuss dispute management by presenting it in a context which highlights our common and valued Jamaican assets, such as coffee, rum and reggae, which indisputably have brought Jamaica worldwide fame and recognition. Since its emergence in 1874 as the Westmoreland Building Society, now rebranded as the Jamaica National Group, formerly JNBS, our organization has always deemed itself a movement, which means that we do not merely see ourselves as a financial entity, but rather as a mutual organization whose mission has always been fueled by the need to facilitate equity and success by bringing people together. Jane Bank is proud to be your partner. Once again, to mount the second iteration of the Dispute Management in a New World webinar series, which brings together some of our most eminent jurists, advocates, and persons of note in the areas of human, social, and economic development here in Jamaica, the Caribbean region, and internationally. We acknowledge the great work that the Jamaica International Arbitration Center has achieved during the past 5 years, and we are honored to be a part of this excellent initiative. As we all endeavor to function and navigate our way through these strenuous and, may I say, unfamiliar circumstances precipitated by the COVID-19 pandemic, dispute management skills are of vital importance as we seek to manage our feelings of stress and frustration exasperated by the new norms by which we must abide. We therefore welcome these forms of conversations in a context which will assist us to cultivate and sustain fruitful and healthy relationships as citizens, as institutions, and as nations. We congratulate the JIC, led by Dr. Christopher Malcolm, for first recognizing the need for this mode of dialogue at this time and for bringing together these distinguished minds over coffee. I anticipate that truly stimulating dialogue will emerge, and we have heard thus far from this event, and I personally look forward to the thoughts and ideas that will emerge and be promulgated in this virtual forum. Jane Bank commends you and endorses this informative event. Thank you.
Thank you very much, Petal. And at this point, I'll simply hand over to Chevelle Logan, who will deliver the vote of thanks. Chevelle is a partner with CPM Consultants, and she has significant experience, including in the quantity surveying field. Chevelle, I hand over to you.
All right. Thank you, Dr. Malcolm. I'll forgive you this time. Most persons get the name pronunciation wrong, so I'll forgive you. For everybody that's out there listening, it is Chevine. To the Honorable Minister Colonel Charles Jr., Dr. Christopher Malcolm, Secretary General of the Jamaica International Arbitration Center, other distinguished guests and participants, good evening. This was indeed a thought-provoking discussion this evening, and I really hope that it opens the door for further discussions amongst our professionals present today. We would like to extend our appreciation to Mr. Maurice Stoppy, who is not only a stalwart in the field of quantity surveying, but also in the field of alternative dispute resolution and arbitration, and in whose honor this lecture is named. We would like to extend a special thank you to the Honorable Colonel Charles Jr. MP for ably delivering our welcome message. I would also like to take this opportunity to congratulate Minister Charles on his appointment. The Council of the Jamaican Institute of Quantity Surveyors certainly looks forward to having discussions with you on the role that quantity surveyors will play in helping to advance the ministry's objectives. We would also like to extend thanks to our main speaker, the Honorable Wayne Martin, ACQC, as well as our panelists, the Honorable Mrs. Justice Zela Mccalla OJ, Mr. Paul Sandersham, and Ms. Aisha Nadar. We want to extend our thanks to Chief Justice Designate Patterson Cheltenham and Mr. Maurice Stoppy for bringing us greetings. And to our moderator, Ms. Karen Goff, we truly appreciate your expert maneuvering of the activities this afternoon. We also want to extend our thanks and appreciation to the Chairman and Secretary General of the Jamaica Institute, the Jamaica International Arbitration Center, Dr. Christopher Malcolm, without whose vision we would not be enjoying this meeting of the minds this afternoon. We would like to recognize the sponsors of this event, whose contribution greatly assisted with this webinar. Thanks to our sponsors, Caribbean Development Bank, ADB Consultants, Jamaica Standard Products, Island Blue Mountain Coffee, that's Island Blue Jamaica Mountain Coffee, Guardian Group, Jamaica National, CPM Consultants Limited, Jamaica Deposit Insurance Corporation, Virgin Gorda Villa Rentals, Burroughs and Wallace, Caribbean Producers Jamaica Limited, Money Musk Rum, and Culture Walk. The media partner for this event was Hype TV, and we want to extend thanks and appreciation to Jonathan Dawes and his team, who did a fabulous job. To the local and international supporting institutions, we say thank you. Gracious thanks also to the team that supported Dr. Malcolm, Ms. Nordia Henry, who took care of marketing and administration, Mr. Mika Campbell, and Mr. Akeem Wilson, who ensured a smooth execution through administrative support. Thank you to our IT support, Mr. Marlon Griffiths, and to the sales team, Mr. Andre Tate and Ms. Denise Erskine Jones. Thanks in advance to Kumar and friends who will be providing the musical treat this evening. To our local and international participants, your attendance helped to make this webinar a success, and we thank you. The next webinar in the series will be held on December 16, 2020. Please remember to register early, and we're looking forward to seeing you then. Thank you all and have a good evening. Over to you, Dr. Malcolm.
Thank you, Shaveen, and you do know that I know your name.
I know you know it. I don't know what happened today.
I wish to remind that you're also the current president of the Jamaica Institute of Quantity Surveyors. Now, at this time, we will turn over, in fact, the proceedings we will turn over the proceedings, in fact, to our entertainment through the musical treat of Kumar. Kumar is simply an amazing musician supported by his friends on this occasion. And without saying more, I will simply now hand over the proceedings as we sit back, relax, and enjoy Kumar in performance.
Bonjour, Moonlight and Chelsea. Hope you all enjoy the movie Stoppy. You understand? As a great movie that of music, we cast live around. My name is Kumar, and I'm on stage right now with my band, the Horror Names, and we're going to play some music for you from my brand new album, Here we go.
We were still fine, waiting for the light to shine. Each day I wake up and face it. I've got my dreams, I wanna taste them. Ooh, better must come, and I'll be trading places. I'll do without the break of dawn. Yeah. Just to be in a better place. I'll walk another avenue. Yesterday became the unknown. Got a feeling something doesn't feel right. So I try my best to make it all right. Feeling like I wanna run. Each day I wake, I'm gonna face it. Got my dreams, I wanna taste them. Ooh, got to keep holding on. And I'll be trading places. I'll do it at the break of dawn, yes. have and put it in another song. And just to be in a better place, I'll walk another avenue, yeah. Yesterday became the unknown, yeah. And oh, believe me, there is hope when all the memories from your past can't hold you down. Oh, believe me, there is hope when all the memories from your past can't hold you down. Yes, I thank you very much. See? So this next song I want to do for you from the album Culture Walk, you know, involves my very good friend and one of Jamaica's best singers and songwriters. Welcome Siobhan Clayton to the stage. See? We're happy to live another day. Where is the chef? Yeah man, so go with something like this. Kick it. Come on again. Say, ha ha. I spent all of my money gambling at the casino, babe. You want it all, then you're gonna lose all of it. And now I'm waiting for another payday. I threw it all away. Glad to live another day. I gained all of my money sitting by the rivers above it. I had all that I wanted, but that couldn't make me happy. Hey, 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 hey. Still I'm glad to live another day. Another day. Yeah. Oh yeah. Glad to live another day. Another day. Yes, I'm so glad that I made it out. And I'm so happy, children. I have to sing and shout, 'cause I know, and you know it's true that to live another day. I thought my life was perfect, just like an Angelo work of art, but things I thought was worth it, now I'm here crying in the back of my car. Wish I could go back to the start. Still I'm glad to live another day. And I'd trade it all in a minute to hear the sounds of a guitar. Would never want it to finish. Stare at the moon, the sky and the stars. I would trade it all, yeah, just to live another day. Another day. Oh yeah, yeah. I'm glad to live another day. Another day. Yeah, one more day, one more day, one more day. glad to live another day. Ooh, another day. Oh yeah. I'm glad to live another day. Javon. Thank you very much. So, I mean, it's a culture walk. A culture walk, and I think, being on a culture walk, it has taken me, through, many different cultures, many different countries, and this next song I want to play for you, is actually one of my favorite from the album. Drop it, Jason. It goes something like this. We'll be sailing on. Woo! Woo! Sometimes the truth coming in some packages. Alright, just listen, check it. Remember 1930, Java, crown with them Queen Hill, Empress Omega, Marcus Garvey, another black leader. Truths and rights worldwide to defeat us. Talking to the leaders, government deceivers, hooking up the planet just for profit every tree cut. Schools in denial every day, they mess your brain up. Doctors say they want everybody about them mucus. Plain white rice, salt them a feed us. Choking on with dreams when the cancer make you wake up. Then it's gone, then it's gone. You can deny what I'm saying, don't deny what I'm saying. Deny what I'm saying, don't deny what I'm saying. You're lost, and we're lost. You can deny what I'm saying, don't deny what I'm saying. Deny how you're living, yes, deny how you're living. You're lost, saying you're lost. Guts and glory sound like a story. Everyone has struggled, don't ever feel sorry. Sorry for your state, man want to change a plate. We living by the seaside, couple grapes then. World of a man, some are God and some are Satan. Just check yourself, don't be another waste man. Rise and shine up to this occasion. Ah, yeah, yes, love. Deny what I'm saying, you know what you're living. Oh yes, you know what you've been through. Oh yes. Sailing on, sailing on. Oh. That's all I'm doing. And I'll be sailing on, sailing on. To the sky, I didn't fall down, oh. Weeping life is just a fairy tale. Do what you gotta do, stay out of jail for life, yes. Sailing on, sailing on. I'll be moving, oh, yeah. Sailing on, I'm gonna be sailing. Sail one. I mean, we could end it. Sailing on. Big up More Life, Health and Strength scene. So, show get interested right now. I want to bring to the stage my brother, Agent Sasko, and this one, small as a grain of sand. Insignificance in life, don't hype up yourself, children of the Most High. Kick it. come on. Low, low. Small as a grain of sand. Small as a grain of sand. Small as a grain of sand. You are to judge. Small as a grain of sand. Small as a grain of sand. Small as a grain of sand. You are to judge. Yeah. Every morning when I wake, live for life in a me teacup. I give your thanks and praise, then I rise up off my knee cup. Don't keep a lot of friends, cause someone fi see me slip up. The real family there, just keep the prayers way up. Staying on my grind, the whole of them fed up. I say what's on my mind, don't tell me figure shut up. Yeah, we shot on the bees, the honey of the makeup. If you're talking to me, please know you have to catch up. Grain of sand.
Hey, what I know you.
Small as a grain of sand.
I never know, say you.
Small as a grain of sand. You are to child.
So insignificant.
Small as a grain of sand.
Smaller than a
small as a grain of sand.
Don't them come on, say.
Small as a grain of sand.
Are you a going
to child?
Hey, watch out. Think you're the biggest thing. You think you're large, yeah. Just because of what you got in your garage and your rank no matter neither. Corporal or sarge, that's all a facade, no realer than a mirage. Hear me? You know it's up in the sky, just big and broad. Should you have a couple shilling and a fancy credit card? It make you feel important, treating people like that. But you see, in the eyes of the Lord, I'm telling you, you see.
Of sand, small as a grain of sand.
Hey, what you know? Say
the small as a grain of sand. You are to judge. Small as a grain of sand. You small as a grain of sand.
Tell them no, tell them no.
You small as a grain of sand.
You are.
I want everybody at home watching. Sing with us now. Sing with us. Watch it. Say glory. Say glory, glory. Say glory,
glory.
Say glory,
glory.
Say glory, glory. Say glory,
glory.
Say glory,
glory.
Say glory. Yes, Jah. Thank you very much. Honorable. Yeah, Sasko. So, in this culture walk that you're having right now, we're bringing up everybody, you know, who's tuning in. And I want to make special mention, you know, of the sponsors, you know, who are sponsoring this right now. You don't know, Jamaica Standard Products. Yeah? And a lot more to be mentioned as we go through. But on this journey that I am on, I'm going to take a culture walk over to the keyboards right now. Play a song for you. Scene. Kick it. My life, my message. What if it's in our heads? Everything that you said in our thoughts, we're programmed from your labs. Drive on, living in your world where we're owned. Yes, it's all gone. We're making people live in war zones. Oh no. Can't wait to escape your program. Nobody's gonna speak out. I have a voice then. I'm gonna jump and shout. Cause the humanoids, they keep making war. The unseen eyes moving the curtain. It's Jaipo. It's so cold. You're making people live in war zones. Oh no, I can't wait to escape your program. What is the price of life? It's doubling each time somebody dies. There's one less worker working on your farm. You're living in your world, it's so cold. Yeah, everybody feel tribal. Making people live in war zones. Oh no, I can't wait to escape your program. That's what it feels like. Yeah. Once cry. Yes, drive on. Living in your world where we're on. Yes, everybody feel tribal. You're making people live in war zones. Oh no, can't wait to escape your program. Very much once more, the culture war, you know. All right, so it's coming to that part of the show where we're gonna, you know, play this song. It really has become an anthem for us, you know. Trumpet. We invite Mr. O'Keel to pick up his trumpet right now. This song needs some heavenly sounds. What do you say? Ready?
Yeah, ready.
Let's go for this one. All right. Before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Do remember me. Do remember. Please remember me. Do remember. Because the youth them nowadays now hold no order. Everyone still a try cross the border. No one to blame, can't point your finger when it is them numbered gas cylinder. Crew what you eat, youth. Dr. Sebi did the talk, he must speak truth. From the other day, everything blend up with the beetroot. Straight greens, man, a chef up, yeah, me feel good. Before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Yes, before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Do remember. Because you're banking your money in a pig, still can't show me where you live. You don't even know where they came from. It's like they came from a strange land. You them nowadays I get sick. Every granny me know diabetic. So before you start move slick, please don't put your money in a toilet. Yes, before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Yes, before I be a slave, I'd be buried in my grave. Oh, Jah, do remember me. Do remember. Please remember. Do remember. Please remember. Check it. Huh. Yeah. Remember my name. Lean to the core from me enter the game. Never switch and never change for the little bit of fame. When me get me give thanks, but do remember. Look what them doing for the glitter on the chain. Look what some doing just to sit up on the plane. Oh, you know if my brother Kabaka pyramid was here, watch it. I be a tomb, I be buried in my tomb. Pan the battlefield like the nanny a maroon. Now I'm gonna sell my soul fi go live a Malibu with the house pan the hillside looking on the view. Now I get caught in a them trap, Mr. Banker. Your mortgage go and go put it back. We no want that. Before me sign one my life in a contract. Point the nozzle and give me one shot. Before I be a slave, I'd be buried in my grave. Oh, Jah, enough for the money. We're not gonna do nothing funny. Yeah. Before I be a slave, I'd be buried in my grave. Oh. Do remember? Do remember? Please remember. So, we're at the end of the show. We're at the final song. Scene. So right now I want to big up, Island, Jamaica, Blue Mountain Coffee, and all the sponsors, who made this possible. I want to big up Chris Malcolm, you understand, and the Jamaica International Arbitration Center. Yeah, so, this would not have been possible. We also want to big up the Hype TV crew. You don't know Johan and team. Big up the Habaneros and big up everybody involved. Scene? You don't know. That is nice. After this, I'm going to drink some coffee and have some. Is it ready? Yeah, I want to drink. All right, well, this one is called Jamaica, and everything you're looking at is Jamaica. Let's go. For tomorrow puts your mind at ease. Rivers running wild, emotions running deep. The hummingbirds are singing sweet like a bumblebee. This love, no rain on your summer. This love, playing in lagoon waters. In Jamaica, whoa, not so far away. I come to Jamaica, island in the sun, get ready to have some fun. In Jamaica, oh yeah, not so far away. Let me take you there. In Jamaica, full of island in the sun, I get ready to have some fun. Come a jam down, make we have some fun. Take off your shoes, put your foot in the sun. Just remember the burning sun. Put on your lotion and your suntan. Me say down at Treasure Beach where you drink quite rum. Red fruit a roses, fish a steam down. Take a culture walk, we get the beat of me heart. You know say the vibes can done. This love, no rain on your summer. Is this love playing in lagoon waters? Yes, in Jamaica, whoa, you're not so far away. Jamaica, island in the sun, get ready to have some fun. Yes, in Jamaica, yes, you're not so far away. In Jamaica, island in the sun, ready to have some fun. Come on, Mr. It's not the day, it's not the night. I'm staring at the moon, I see a future, it's so bright. Every day's a holiday, and I know a hideaway. We can go and watch that sunset, then jump off at Ritz Cafe. And this love, no rain on your summer. This love, in lagoon water. Jamaica love, Jamaica love, Jamaica love, Jamaica love, Jamaica love. Feeling nice, feeling fine. Yes. So Jamaica love, Jamaica love, Jamaica love, Jamaica love. Oh yes, I'm floating by, floating high. Yes. So in Jamaica, ooh, oh, not so far away. Let me take you there. In Jamaica, ooh, love island in the sun. Get ready to have some fun. Get ready to have some fun. Jamaica, ooh yeah. Jamaica love, Jamaica love. Thank you very much. My name is Kumar, and we're the Habaneros. That's the part. I'd like to thank the organizers. You don't know, Jamaica International Arbitration Center, Chris Malcolm and team, and also the sponsors: Jamaica Standard Products, Island Blue Jamaican Mountain Coffee, Caribbean Producers Jamaica Limited, Money Musk Rum, CP Malcolm Dispute Management Practitioner, 39 Essex Chambers, London, Virgin Gorda Villa Rentals, Luxury Holiday Villas, ADPB Consultants, Burroughs and Wallace, and also Culture Walk. You don't know our media partner, Hype TV, Yohan Dawes and team, and our local, regional, and international supporting institutions. Big up, thank you a lot.
Stop share. Stop share. No, stop.
Okay, thanks much for those of us who stayed to the end. I certainly had a wonderful time following Kumar, and there is in fact an extended version of this that will be available on our YouTube channel. Thanks again for having shared the time to everybody. We have already had our formal vote of thanks, and I will not redo it. But do join us in December for the next in our event, and every other month thereafter for a series event that will continue as we continue to build out an information that we have available and find responsive ways to deal with emerging trends and things that are quite frankly able to help us to sustain our economies and to move our systems for administration of justice and for resolution of disputes further and forward in a way that we can be comfortable. Thanks again for being with us, and do have a wonderful rest of the evening, the day, the morning, whatever time it may be in your region. And we will see you again next time. Thanks again. Have a good rest of the evening, morning, day. Bye-bye.